The UK's December 2025 deportation notice has triggered one of the biggest immigration crackdowns in recent years, and thousands of people are now asking the same question. Do I need to leave before 2026? New digital checks, stricter rules, and real-time tracking systems mean that even small mistakes can decide who stays and who must go. Whether it's overstayed visas, rejected extensions, or updated laws affecting families and workers, the criteria have tightened sharply. If you're in the UK right now, understanding these changes is crucial, because the new system identifies non-compliance faster than ever before. Number 1. Overstayed visas. The December 2025 enforcement update places a strong focus on individuals who have remained in the UK beyond the expiry of their visa, even for short periods. Overstaying has always carried consequences, yet the latest system upgrade has made detection faster and far more automatic. The Home Office now receives real-time data from employers, universities, landlords, and digital border records, making it difficult for anyone without valid leave to remain unnoticed. Once an overstay is flagged, the person becomes subject to a mandatory departure requirement before 2026, along with restrictions that prevent future applications for several years. Many individuals underestimate how quickly an overstay develops, especially when dealing with delayed paperwork, missed emails, or misunderstanding of visa expiry dates. The updated system no longer accepts these mistakes as reasonable grounds, as every visa holder is expected to monitor the status of their digital immigration record. The Home Office has stated that the 2025 removal drive aims to reduce the number of people living in the UK without lawful status, which means enforcement officers are prioritising checks in workplaces, transport hubs, and accommodation sites. Anyone identified without valid permission is directed to leave before the year ends. To avoid forced removal under the 2025 rules, individuals must review their visa conditions carefully and confirm whether their leave remains active on the official digital platform. Many people discover problems only after attempting to rent property, start new employment, or register with a service that checks immigration status. Acting early can prevent stricter consequences, as voluntary departure is viewed more favourably during future applications. Those unsure about their status should gather documents showing their entry date, visa type, and communication history, allowing them to correct potential errors before enforcement activity increases near the end of the year. Number 2. Failed asylum applications. The December 2025 deportation notice places significant emphasis on asylum seekers whose claims have been refused under the new fast-track decision system. Throughout 2025, the Home Office accelerated processing times, and thousands of pending cases received final decisions in the last quarter of the year. Anyone whose claim has been rejected and who has exhausted all appeal rights is now included in the priority removal list. The new framework focuses on closing long-running cases and clearing the backlog before 2026, which means individuals with no legal basis to remain are being contacted and instructed to depart within a fixed deadline. Many applicants previously relied on slow case movement or ongoing administrative delays, which often allowed them to stay for extended periods. That window has now closed. The upgraded 2025 digital case management system alerts the enforcement team immediately when an asylum file reaches the "no further appeal" stage. Once this flag appears, the person can be issued a formal notice requiring departure. Those who choose not to leave voluntarily risk being placed in short-term holding centres or temporary reporting facilities until removal arrangements are completed. The Home Office has already confirmed that resources for detaining non-compliant individuals were expanded during autumn 2025. People affected by a refusal must act quickly, as remaining in the UK after receiving a final negative decision can lead to long-term consequences for future immigration attempts. Anyone seeking to challenge their outcome must ensure they submit fresh evidence that genuinely changes the original assessment, because weak or repetitive submissions are dismissed rapidly under the new rules. Individuals should also keep records of medical needs, dependents, or credible risk factors if they plan to present a fresh claim. Understanding the deadlines in their decision letter is essential, as the Home Office is expected to carry out intensified enforcement from December onward to ensure timely departures before 2026. Number 3. Illegal entry. After March 2025, the December 2025 removal framework places individuals who entered the UK illegally after March 2025 at the highest level of enforcement priority. The new legislation, passed earlier in the year, states that anyone arriving without authorised entry, proper documentation or border clearance is automatically considered for removal. This rule applies to those who arrived through small boats, concealed transport routes, or by bypassing official checkpoints. Under this system, biometric matching and digital border logs identify irregular arrivals much faster than before, and once flagged, the person receives a notice instructing them to leave before 2026. The Home Office has repeatedly highlighted that this measure aims to deter unlawful crossings and strengthen border control ahead of new immigration targets. Individuals affected by this category often had limited options or incomplete understanding of the post-March 2025 regulations. Earlier policies allowed some irregular entrants to apply for asylum inside the UK, yet this pathway has been significantly restricted. Those entering illegally after the cut-off date are classified differently, and their claims are assessed under a system designed to prioritise rapid removal. The updated model uses international data sharing agreements, enabling the UK to trace migrant movements more accurately and confirm whether a person passed through a safe third country. When this evidence is confirmed, the individual is instructed to return to that safe country rather than remain in Britain. Enforcement teams have been increasingly visible at ports, accommodation centres, and transport hubs to ensure the new rules are applied consistently. Anyone in this category must understand that remaining in the UK without addressing their situation creates additional barriers for the future. Ignoring departure notices leads to travel bans, detention, and restrictions that stretch across several years. Those seeking legal options must collect accurate records of their route, identity, and humanitarian reasons, as only significant new information has a chance of review. With increasing checks expected in the final weeks of 2025, individuals should focus on understanding their legal position clearly, preparing documentation, and responding proactively to avoid harsher consequences as the new year approaches. Number 4. Rejected work visa extensions. Work visa extensions have become significantly harder to secure under the updated 2025 immigration rules, and many individuals now face mandatory departure before 2026 after receiving a refusal. The skilled worker route experienced major policy changes during the summer and autumn of 2025, including a higher salary threshold and stricter employer verification checks. Employers must now prove genuine labour shortages, provide transparent financial records, and demonstrate consistent compliance with sponsorship duties. When these conditions are not met, the extension request is automatically flagged, leading to a refusal notice. Individuals who receive this outcome are instructed to leave within a defined period, because their right to work ends the moment the extension is rejected. Many applicants assumed their extension would be routine, especially those who had held the same job for several years. The 2025 system removed many of the previous allowances that helped long-term employees stay while resolving administrative mistakes. Even small inconsistencies, such as job title changes, salary discrepancies, or delays in employer paperwork, can now cause a rejection. The Home Office cross-checks data from payroll systems, digital tax records, and company sponsorship histories, meaning errors are detected rapidly. Once a refusal is issued, individuals cannot continue working, and remaining in the UK without an active visa is treated as unlawful stay. Enforcement teams have been focusing on workplaces where sponsorship irregularities were recorded throughout the year. Anyone facing this situation must review their decision letter carefully and understand the exact reason for rejection. If there is strong evidence that the decision contains an error, a reconsideration request is possible, yet it must be supported with clear documentation. Those seeking to switch to another route must confirm eligibility before submitting any new application. Gathering pay records, updated contracts, employer support statements, and accurate job descriptions can help clarify their position. The critical step is acting before the deadline expires, as the December 2025 framework emphasizes timely departures for anyone whose extension cannot be approved, with increased monitoring expected as the year reaches its close. Number 5. Family visa non-compliance. Family visas have faced one of the strictest rounds of checks under the December 2025 enforcement update, and non-compliance now leads directly to removal orders before 2026. The Home Office increased the minimum income requirement, expanded relationship verification procedures, and strengthened housing checks across all partner and spouse routes. Anyone who fails to meet these conditions or provide clear evidence of a genuine relationship is flagged through the 2025 digital verification system. Once flagged, the individual receives a notice requiring voluntary departure within a set timeframe. These measures aim to reduce unresolved family visa cases and confirm that applicants meet every requirement listed in the latest framework. Many families underestimate how detailed the compliance checks have become. The system now cross-matches data from bank statements, tenancy agreements, utility bills, and national insurance records, making inconsistencies easier to detect. Applicants who previously relied on partial documents or outdated financial records face greater scrutiny, because the Home Office now reviews income stability rather than isolated earnings. Couples must also show consistent communication, shared responsibilities, and credible proof of long-term cohabitation. When evidence is weak or incomplete, the application is refused, and the individual must prepare to leave before enforcement activity increases in late December. These checks were introduced to prevent misuse of family roots and ensure that dependents are living in secure and stable circumstances. Anyone affected by non-compliance must understand their position quickly and gather accurate records that demonstrate their eligibility. Reviewing bank statements, rental agreements, photographs, medical records for dependents, and communication logs can help clarify their case. If a genuine error occurred, a new application may be possible, yet it must address every point raised in the refusal notice. Those choosing to leave voluntarily can avoid long bans that restrict future entries. Since the updated system runs automatic checks throughout the month, individuals should respond promptly to any notification, prepare required documents, and make clear decisions before deadlines approach, preventing further issues as the UK completes its enforcement cycle for the year. Number 6. Criminal convictions and police flags. The December 2025 deportation framework places strong emphasis on individuals with criminal convictions or repeated police warnings, even when offences appear minor. The Home Office expanded the public safety removal list, meaning anyone flagged under the updated policing database can be instructed to leave before 2026. The system now includes digital links between local police, border forces, and immigration enforcement, making it easier to detect patterns of behaviour involving theft, repeated disturbances, fraudulent activity, or breaches of public order. Once a person appears in this category, the Home Office assesses the risk they pose to community safety and issues departure notices for those considered unsuitable to remain in the UK. This category is not limited to serious offenders, as repeated minor issues can also trigger enforcement action under the expanded criteria. Many individuals do not realise that police flags now carry greater weight than earlier years. The updated digital record system, introduced in mid-2025, automatically highlights any foreign national who has been arrested, cautioned, or repeatedly reported, even if the case did not lead to a prison sentence. This system aims to prevent unresolved cases from staying unnoticed and ensures that immigration officers are alerted whenever risk-related behaviour appears. The Home Office has publicly stated that community protection is a core part of the 2025 removal drive, and this includes situations where a person has shown ongoing disregard for regulations. Housing associations, local councils, and social service departments also share information, allowing authorities to map patterns of behaviour that may otherwise remain concealed. Anyone in this situation must review their records and understand how the Home Office interprets their case. If errors exist, individuals should request clarification from relevant authorities and collect documents that demonstrate positive behaviour, rehabilitation steps, or community involvement. Legal representatives can help identify whether the conviction triggers automatic removal or whether the individual can challenge the decision with updated evidence. Taking action early is important because removal processes speed up significantly during December. Responding to notices, preparing documents, and understanding the timelines can help individuals manage their situation more clearly before enforcement reaches its final phase for the year. Number 7. Expired student visas. The December 2025 enforcement update places strong focus on international students whose visas have expired or who have not complied with the conditions of their study route. Universities and colleges now share real-time data with the Home Office through an upgraded attendance and enrolment monitoring system. When a student fails to enroll, stops attending classes, or leaves a course early, the institution sends an immediate alert that marks the visa as non-compliant. Once this happens, the student becomes subject to a mandatory departure before 2026 because the system treats them as no longer meeting the purpose of their stay. The goal of this policy is to address misuse of the student route and ensure that sponsored education places are occupied by genuine learners. Many individuals fall into this category without realizing how strict the updated monitoring process has become. Missed classes, incomplete modules, unpaid tuition fees, or late registration can all activate warnings in the shared system. The Home Office analyzes these records alongside financial statements, attendance logs, and progression reports to confirm whether a student is still actively studying. If gaps or inconsistencies appear, the visa is curtailed and a departure notice is issued. Students who rely on part-time work must also remain aware of hourly limits, as exceeding them leads to breaches that further complicate their status. The expanded compliance model was introduced to ensure that educational institutions maintain accurate reporting, and those who do not meet expectations face swift removal procedures. Anyone affected by an expired or curtailed student visa must take immediate steps to understand their situation and gather documents that prove ongoing academic engagement. Attendance letters, updated enrollment confirmations, bank records for tuition payments, and emails from academic departments can help clarify whether an error occurred. Those who left their course early must prepare to depart before deadlines, because remaining after expiry causes future restrictions on study routes. Students wishing to switch to another visa category must confirm eligibility and ensure they meet every requirement before submitting an application. With increased checks expected throughout December, taking timely action helps avoid penalties that could affect future opportunities in the UK. Number 8. Failed to update address and biometrics. The December 2025 Immigration Enforcement Update places major attention on individuals who have not kept their digital immigration records accurate, especially regarding address changes and biometric updates. The UK's new digital status system requires every visa holder to maintain an active and updated profile because the Home Office uses this information for compliance checks. When someone changes accommodation, starts a new job, or moves to a different region, the system expects the update to be submitted immediately. Failure to do so triggers a non-compliance alert, and individuals listed with outdated details can receive removal notices before 2026. Authorities use these checks to confirm that people remain reachable and continue to meet the conditions of their stay under the upgraded 2025 framework. Many people underestimate how important these updates have become. Earlier systems allowed some room for delays, yet the digital platform introduced in 2025 removes that flexibility. The Home Office now cross-references immigration data with council records, NHS registrations, school admissions, and employer files, which means outdated information becomes visible instantly. If a person cannot be contacted at their registered address, the system classifies the case as a breach, and this can lead to the cancellation of their visa. Biometrics also play a major role. Individuals who receive biometric renewal notifications must attend appointments or submit digital scans within the given deadline. Missing these steps results in the loss of lawful status, creating a direct pathway to deportation proceedings. Anyone affected must act quickly and review the accuracy of their digital profile. Updating the address, confirming contact details, and completing any pending biometric requirements can prevent further issues. Individuals should gather proof of residence, tenancy agreements, and identification documents to resolve errors. Those who believe a system mistake has occurred must raise the issue promptly with supporting evidence showing their real address history. Responding early is essential because enforcement activity intensifies throughout December. Ensuring that all digital records remain correct helps avoid penalties that could impact future applications or re-entry options as the UK finalises its 2025 compliance checks. Number 9. Working in breach of visa conditions. The December 2025 enforcement update highlights a growing number of cases involving individuals who worked outside the limits of their visa conditions. This includes students working more hours than permitted, visitors engaging in paid activities, and skilled workers taking roles that do not match the job description approved in their sponsorship certificate. The Home Office's upgraded verification system cross-checks employment records, payroll information, tax submissions, and sponsorship data to identify irregularities automatically. Once a breach is detected, the individual is classified as non-compliant and can receive a notice requiring departure before 2026. These rules are designed to ensure that visa routes remain aligned with their intended purpose and prevent misuse of employment opportunities. Many people unintentionally violate work conditions due to confusion around updated regulations. Students often accept extra hours during busy seasons, unaware that the system now tracks work activity through national insurance and employer reporting tools. Visitors who assume small freelance tasks will go unnoticed are often flagged by automated activity monitors. Sponsored workers face challenges when employers shift roles, modify responsibilities, or adjust working hours without notifying the Home Office. These changes create mismatches between the digital sponsorship record and the actual job being performed. When these mismatches appear, the system marks the role as incompatible with the visa, triggering further investigation that leads to removal notices in many cases. Employers also face penalties for failing to maintain accurate records. Anyone in this category must reassess their work history and confirm whether every task aligns with their visa rules. Collecting payslips, employment contracts, working hour logs, and sponsorship documents helps identify whether a breach occurred. Those with genuine misunderstandings may request clarification or submit evidence showing compliance. Individuals seeking to switch to another route must first ensure they meet the eligibility criteria fully before submitting a new application. Responding promptly and adjusting work activities to remain within allowed limits can reduce further complications. With increased checks expected throughout December, staying fully aligned with visa rules is essential to avoid long-term restrictions or enforced departure as the year closes. Number 10. Dependents without valid permission. Dependents face stricter scrutiny under the December 2025 enforcement update, especially children, partners, and elderly family members whose visas have expired or were never renewed correctly. The digital immigration system now checks every dependent record linked to a main applicant, and if even one profile shows a lapse, the entire family receives compliance alerts. Many families assume that dependents are automatically covered when the main visa holder extends their own status. Yet the 2025 rules require each individual to hold separate active permission. When the system detects missing documents, expired leave, or incomplete biometric records, it issues notices requiring those dependents to leave before 2026. These measures were introduced to prevent long-term overstays caused by administrative oversights within family units. Many cases arise from simple misunderstandings, such as parents forgetting to renew a child's visa when updating their own work or study route. The Home Office now cross-references school admission data, GP registrations, and housing records to confirm whether every dependent remains lawfully present. When a mismatch appears, the system marks the dependent's profile as expired and triggers a curtailment process. This alert often surprises families because earlier systems allowed more flexibility, yet the 2025 upgrade makes automatic checks extremely precise. Dependents who arrived at different times, entered on different routes, or changed sponsors over the years are especially vulnerable to errors. Once flagged, the dependent is expected to depart within the deadline, and failure to comply affects the future immigration options of the entire household. Anyone in this situation must review each dependent's digital status individually to confirm active permission. Important documents include birth certificates, biometric cards, appointment confirmations, and proof of consistent residence. Families may submit updated records if the lapse resulted from mistakes, yet evidence must clearly address the missing details. Those unable to meet requirements should prepare for voluntary departure to avoid longer bans. Since enforcement checks intensify during December, taking immediate steps to clarify every dependent's status helps protect future applications and prevents complications that could restrict re-entry opportunities in the coming year. The December 2025 Deportation Notice has reshaped the UK immigration landscape, creating a system that responds faster, checks deeper, and flags issues with far more accuracy than previous years. Every change introduced during 2025 moves toward one clear goal: ensuring that only individuals with valid permission and full compliance remain in the country. This means even small oversights, missed biometric updates, expired dependent visas, incorrect work roles, or gaps in student attendance now carry serious consequences. For anyone living in the UK, Staying informed and reviewing their digital immigration records is essential because the new system links directly to workplaces, universities, councils, and national services. Understanding these updates can help people take action before deadlines tighten in the final weeks of the year. Whether someone is managing a work route, running a family application, or studying under strict attendance rules, awareness is the strongest safeguard against unexpected removal orders. Clear paperwork, accurate digital records, and timely responses are more important than ever as enforcement activity increases across the UK. If this breakdown helped you understand the new rules, make sure to like the video, subscribe for ongoing UK immigration updates, and share your experience or questions in the comments. Your situation might help someone else facing the same challenge.